Welcome to EML's webcast on shared parental leave, which should last about 10 to 15 minutes. My name's Debbie Knowles and I'm Managing Director of EML. So where do I start? In terms of the range of rights broadly known as family leave, we've currently got ordinary maternity leave, additional maternity leave, ordinary paternity leave, additional paternity leave, and not forgetting ordinary adoption leave and additional adoption leave. To add to all of this, we've now got shared parental leave. Not to be confused, I hasten to add, with the parental leave of the non-shared type, which we've had for some years, i.e. that which entitles parents of children up to the age of 5, soon to be 18, to 18 weeks unpaid time off. Confused? Well, so were we. It took 5 sets of lengthy regulations to bring this right into being, and in approximately 10 minutes I'll try to cut through them and summarise what it's all about. Here goes. Let's start with a brief summary of the current position. Mothers are entitled to up to 52 weeks of leave and 39 weeks of pay. Fathers with at least 6 months service are entitled to 2 weeks of leave at or around the birth of a child, known as ordinary paternity leave, and then up to a further 26 weeks when the baby is between 20 weeks and 1 year old, providing the mother has returned to work. This is known as additional paternity leave. All of that largely remains unchanged, except that the right to additional paternity leave, that is, the further 26 weeks, will be repealed for parents of children whose expected week of childbirth is on or after the 5th of April. The right to SPL is already on the statute books and has been since the 1st of December 2014, but is only available to parents of babies with an expected week of childbirth on or after the 5th of April 2015. Under the new right to shared parental leave, parents will be able to share up to 50 weeks of leave between them. Now, the first thing to note is that whilst the entitlements to maternity leave are still the same, the amount of shared parental leave is not in addition to the amount of maternity leave available. Only 52 weeks of maternity leave or shared parental leave can be taken in total. So if the mother takes all 52 weeks of maternity leave to which she is entitled, there will be no entitlement to shared parental leave for either her or her husband or partner. In order for a mother or her partner to take shared parental leave, the mother must have brought her maternity leave to an end early, in which case it is the remainder of what would have been the maternity leave period, which can be taken by either parent as SPL, shared parental leave. The reason why it's 50 weeks of SPL and not 52 is that the first 2 weeks after the birth are compulsory maternity leave, which is actually 4 weeks for women who work in factories. What differentiates SPL from maternity and paternity leave is that parents can take it at the same time or consecutively, i.e. they could each take 6 months off together rather than one taking 6 months, returning to work, and then the other taking 6 months. In addition, and perhaps of more concern to employers, is that shared parental leave can be taken over a number of separate periods, and those might be continuous periods, for example 2 months taken together, or they could be discontinuous periods, for example 1 month of leave followed by 1 month back at work, then 1 month of leave, 1 month back at work, and so on. More of this to come. Shared parental leave pay is available for up to 39 weeks, the same as statutory maternity pay, but is payable only at the flat rate, which is the same as the flat rate of statutory maternity pay and statutory paternity pay, or 90% of the person's earnings if that is less. There is no entitlement to 90% of earnings for any of that period if that is higher than the flat rate. Finally, in their wisdom, the government has introduced split days to add to existing rights to kit days. Split days are shared parental leave in-touch days, which allow an employee on shared parental leave and receiving shared parental leave pay to work for up to 20 days during that period without bringing their entitlement to parental leave pay to an end. But there is no obligation on the employer to offer split days, or indeed on the employee to accept them if offered. So, who is eligible for shared parental leave? Clearly the mother and father if they live together and share care for the child, or the mother's spouse, partner or civil partner if they are an enduring family relationship and share responsibility for the child's upbringing. I should note here that the right to shared parental leave is also available for parents of adopted children where the expected week of placement is on or after the 5th of April 2015. However, for ease, we won't differentiate between the two further in this webcast. The rights are exactly the same. In all cases, the employee requesting shared parental leave, whether the mother, father or partner, must have at least 26 weeks continuous service with the employer at the 15th week before the expected week of childbirth. There is also an employment and earnings test which the other parent or partner must pass. So if the mother wants to avail herself of shared parental leave, her partner must be economically active. This means that he or she must have been working or self-employed for at least 26 of the 66 weeks before the baby is due and earning at least £30 in each of 13 of those weeks. Shared parental leave pay is only available where the mother qualifies for statutory maternity pay. Up to 39 weeks is available for the parents to share, but if statutory maternity pay has already been paid for any period, then this is deducted from the number of weeks of shared parental pay available. In reality, this means that actually only up to 37 weeks is available, as the mother will have had to take at least 2 weeks of compulsory maternity leave at the birth of the child. So we know broadly what the right to shared parental leave is, but how do employees take advantage of it? Well, it's a 3-step process. First of all, the mother must provide her employer with a curtailment notice at least 8 weeks prior to the date on which she wants her statutory maternity leave to end. Secondly, the employee who wants to take a period of shared parental leave, and this could be both, must provide their employer with a written notice of entitlement at least 8 weeks before they wish their shared parental leave to commence. So in many cases, the curtailment notice and written notice of entitlement will probably be provided together. The written notice of entitlement must provide the information detailed on the slide. Note that there is no obligation on the employer to check the truthfulness of this statement. The employer can ask for a copy of the birth certificate and the name and address of the partner's employer, but it doesn't have to. Finally, there is a period of leave notice which must be provided to the employer at least 8 weeks before an employee wishes to commence any single period of shared parental leave. This must state the details on the slide. Each parent or partner can make up to 3 separate requests for shared parental leave for any one birth. Where a request is for a continuous period, example 1st of March to 1st of June, the employer can't refuse it. If a request is for a discontinuous period, however, so for example 2 weeks of every month for 3 months, the employer can refuse it as long as it's within 14 days of the request. In that case, the employer then has 14 days to agree an alternative pattern of leave with the employee, failing which the leave must either be taken as one continuous period or the request can be withdrawn by the employee altogether. So what are the parents' rights on their return to work after a period of shared parental leave? These largely mirror the rights of a person returning from statutory maternity leave or statutory paternity leave. If 26 weeks or less of leave have been taken in total, and that refers to shared parental leave combined with any period of maternity leave or paternity leave also taken, then the employee must be allowed to return to the same job on the same terms and conditions. There are 1 or 2 exceptions where a period of shared parental leave has been combined with a period of additional maternity leave or a period of parental leave of 4 weeks or more. in which case the employee can be treated the same as an employee who has taken a period of combined leave of more than 26 weeks, which we'll come to now. For an employee who has taken a period of leave of more than 26 weeks, again taking into account shared parental leave and any maternity or paternity leave taken, that employee must be allowed to return to the same job, or if it isn't reasonably practicable to allow them to return to their own job, then they must be offered a suitable alternative which will be on terms and conditions no less favourable than those relating to their previous job. As with maternity and paternity leave, an employee taking or seeking to take shared parental leave is protected from any kind of detriment or dismissal, and doesn't need any minimum level of qualifying service to bring such a claim in the employment tribunal. So, what do you need to do next? As a minimum, review any existing policies on maternity and paternity leave and implement a policy on shared parental leave. Determine how your organisation will deal with things such as asking for evidence of entitlement to shared parental leave, and ensure that as far as possible you're consistent with all employees. Train managers on your policy and ensure that employees are aware of it. This is a complicated area and we can only hope to summarise the position here. For further information, or if you have any specific questions, please don't hesitate to get in touch with one of our consultants who will be more than happy to advise. And finally, we'd be very grateful if you could drop us a line through the website to let us know whether you found this webcast useful, and also any further topics which you would like to see covered. Thank you for listening.